Good afternoon, everyone, and welcome to the third session of our webinar series on the new Title IX regulations. I'm Tom Mercurio at the University of Vermont, and for myself and the whole UVM continuing and distance education team, I thank you for tuning in. I apologize also for the technical problems that have caused us to have to do this in a recorded format. We are pleased nonetheless to connect with you remotely and to be able to keep the conversation going about the new Title IX regulations. Some of you may have been here before. In our first session back on June 10th, we began our examination of the new Title IX reality with an overview and introduction to the new federal regulations. In our second session on the new Title IX on June 30th, we offered an expert panel to respond to your questions. Today, our third session is called Wait, the new Title IX rules apply to employees? We look forward to an engaging discussion today. Remember to post your questions. How do we post our questions? Via email, and we'll try to work them into our final presentation. I'd like to welcome now our presenters. First, Lili Palacios-Baldwin, who's Associate General Counsel at Tufts University. Oh, I'm sorry, Seth is first. Lili is, although she specializes in labor and employment, like all in-house counsel, she does a little bit of everything. Welcome, Lili. It's nice to have you join us, UVM team. Next, Seth Gilbertson, Associate Counsel with the State University of New York, now in Buffalo, I believe, right, Seth? And our dependable friend, Scott Schneider, a partner in Husch Blackwell in Austin, Texas. Scott, thanks again for joining us. We'll begin with, I'll turn over the clicker to Seth, who will present this live presentation and begin our audio and video presentation. Seth, take it away.
Thanks, Tom. Appreciate having you help us out with this. I know it was a last-minute request, so thanks for jumping in. I'm going to start off with just a brief bit of history here, and it's actually where I'm going to start is not Title IX, but Title VII, and it was actually an amendment to Title VII that I want to start off very quickly with here. One of the things that Title VII has been around for about 8 years, but in 1972, Congress decided that Title VII needed a little bit more teeth, or the EEOC needed a little bit more teeth, and the EEOC was given authority to enforce Title VII through instituting its own civil actions against employers. At the same time, an educational institution exception was eliminated from Title VII. So one of the themes you're going to see arise today, I think, is sort of the difficulty of applying both Title VII and Title IX, the overlap, the dovetailing, however you want to put it. And this is where that really started in March of 1972, although Title IX wasn't around for 3 months later, in June of 1972, when Title IX was passed. And you all are familiar with the basic language of Title IX, so I'm not going to read it here, but about 3 years after that, then, what was then the Department of Health, Education, and Welfare, who was the secretary actually at the time was Caspar Weinberger, who many of you may probably think of as the Secretary of Defense much later in his, or a little bit later in his career. I don't know what he was trading textbooks for then, but he later would trade arms for hostages. The first Title IX regulations were promulgated in 1975. This is the first time that we see employment specifically covered. I think it was a bit ambiguous at first with this language. Does it apply to employment? Does it not apply to employment? Most people thought of it as a student statute, I think it's fair to say. But in 75, the Department of Health, Education, and Welfare comes out specifically to say that the regulations do apply to employees of recipient institutions, programs, and activities. Now, at the time, actually in 72, in 75, the department received 10,000 responses, 10,000 comments on those regulations, which at the time, maybe a bit of foreshadowing here, was by far the most comments they had ever received on any regulations they had promulgated to date. That number would be bettered several dozens of times over later on in 2019. But as many of you are aware. But in 75, there was a lot of activity. None of that activity, none of those comments actually questioned the application of Title IX to the employment sphere. That was first done in 1972 in a case that made it to the Supreme Court out of the New Haven Board of Education, where the Supreme Court, 72 I believe it was, held that in fact the language, legislative history, and post-enactment history of Title IX did support its application to employment. Now I'm going to jump over some rather significant developments in the next, including the Gerber-Davis decisions, which said that harassment was actionable under Title IX, and we're going to jump forward all the way to 2005 to this decision, Jackson v. Birmingham Board of Education, that the main thing the case is known for is saying that Title IX did apply to cases of retaliation, to allegations of retaliation. Believe it or not, that was a 5-4 decision. So if one judge on the Supreme Court would have ruled the other way in 2005, you would see a drastically different Title IX. You can imagine a Title IX with no retaliation provision would be very difficult to enforce and really lack a lot of the teeth that it has today. That being a key part. The other thing that Jackson did is extend, or it may have been implied, the court didn't specifically address it, but the first time the Supreme Court sort of put a stamp of approval on the extension of a right of action to employee claims. So that's obviously something that's significant for all of us now. Now, in some of the intervening years and in the years after, many of us are familiar with guidance and DCLs that have come out of the Department of Education. One thing that is notable about those for today's discussion is that in none of these was employment, the application of Title IX to employment a significant consideration. The 1997 guidance specifically said, basically, go look at Title VII. They really kind of disclaim application to employment. They don't say it doesn't apply to employment. The regulations were still in effect applying it to employment, but they said we're going to let the EOC mostly handle that. We're going to let it mostly be done under Title VII. 2001 and 2011 both refer back to, or sorry, 2001 refers to 97, 2011 refers to 2001, all pushing complaints toward EEOC procedures. 2015 does mention employees in that it requires that the dissemination of procedures and identification and contact information for Title IX coordinators, that information also had to go to employees, so at least employees were considered in 2015, and that guidance actually is still in effect. So that one's still out there. In 2017, some of the other ones, guidance and Dear Colleague letters were withdrawn, as many of you know. Interim guidance was published. Some of us are familiar. It does require publication again of complaint procedures to employees. And then over the next 2 years, we got the proposed regulations, and then ultimately the final rules published, as all of you know, a couple of months ago. Now, that's what should bring us up to today, but I'm going to look forward just a little bit here, just because I can't help myself, but throw out a little future problem that we're going to face. It may or may not be considered a problem. It's going to be another thing that we have to deal with, and that is further expansion of the coverage, potential further expansion of the coverage of Title IX. Many of you are familiar with the Supreme Court's expansion of Title VII to cover claims of discrimination on the basis of homosexuality or transgender status. If you look at the language of that decision, it's going to be very difficult to figure out how that language will not also apply to Title IX. Basically, you have Title VII saying because of discrimination, because of sex, and Title IX saying on the basis of sex. It's difficult for me to figure out how that difference in wording is going to lead to a different conclusion when it comes to whether or not on the basis of sex applies to homosexuality or transgender status discrimination protection. And with that, I will turn it over to Lili.
Thanks, Seth. That was really an interesting and good background to where we are now. And I think what I wanted to try to focus on to get us towards some hypos that we'll also be discussing to kind of really put our thinking caps on some of the issues that we'll be dealing with is just some of the implementation issues that we've been dealing with on campus. And I say we, not necessarily at Tufts, but I know that many of my colleagues in higher education are dealing with a number of things right now, including Title IX. And I thought it might be helpful to kind of go through a few things that I thought have been helpful, particularly if folks are trying to identify some things that they would like to prioritize. So one of the things that I have talked about a lot is identifying a study group on campus, basically a group of folks who you can read the regulations with, think about your policies and procedures and your stakeholders in mind with, not just Title IX, but also thinking about Title VII and the related guidance. I will tell you that if folks have not taken a look at recently the EEOC's guidance on vicarious liability, which applies to harassment, not just on the basis of sex, but other bases, it's a really great refresher for this specific issue, because the topic of this webinar is perfect. A lot of folks have not been focused on the implications of Title IX for employees, and really thinking about the Title IX regs and then what else exists already for employees is going to be an important first step to thinking about implementation. Determining what can stay the same, what needs to change, and what changes will require the most work is also an important step. And I'll talk about that a little bit more afterwards in terms of just identifying change agents, which I think will be really important in the employee space. We've had a lot of change agents, primarily students in the student space, and I think we may need some change agents on campus to focus on some of the employee changes that we'll be implementing. So that relates also to socializing the changes in terms of getting folks oriented with how this is, yes, in fact, that new Title IX rules apply to employees, and this is how we're going to address that, getting some education out and getting, of course, some feedback on how you potentially plan to implement some of the changes. Budgeting is something that I think applies to both the implementation aspects of this for employees and students, but I think nonetheless something that is important to think about if schools are thinking about whether or not they want to hire investigators, if they haven't hired investigators as folks internally yet, hearing officers and the like. I'm going to tick really quickly through what I've identified as heavy lifts and then sort of light lifts or low-hanging fruit that I think folks can be focused on when thinking about the Title IX rules and employees. Some of this also, of course, helps with students, but drafting and revising policies and practices, I think that's the heaviest lift. I know that Scott and Seth are probably both up to their top with tons of review of policies and procedures, not just of sexual misconduct, but other policies that might dovetail. Drafting or revising hearing and appeals processes. We at Tufts have not had a hearing process for many years as a result of input from students who had real concerns about the hearing process. We're now going to have to pivot to a hearing process. So we'll be developing a hearing process, and we've always had an appeal process, but putting those two together. So folks may be creating those from the bottom up. Deciding on key issues. Some of the key issues that we've been thinking about are hearing officers, investigators, advisors, who are going to be those folks and what kind of training will they have, and do we want those folks to be external or internal? And then, of course, jurisdiction, and I think probably to some extent a lighter lift, record keeping. I think as a big institution, even smaller institutions will be having to think about whether they need to revise record keeping procedures and policies. Some of those things are going to be, take a lot of time. Strategizing communications with unions, faculty senates, and employee groups. I work a lot with our unions on campus. I think many of the folks who are speaking today do as well. And you'll notice that the regulations have some updated requirements for schools to ensure that labor unions in particular, but also their employees, are aware of policies, procedures, the identity, and the way to contact the Title IX coordinator. And the real question will be whether that's something that you're going to just put out in kind of an indirect way, or whether that's something that you're going to put out to unions and to employees in a way that might be more interactive. So that will be something that I think every school will have to think about. If you have a really good relationship with your union partners, you may want to sit down and talk about how the regs are going to be implemented on campus and how, if at all, they will implicate the CBAs. I think this could actually be a really good opportunity to partner and collaborate with labor if you have the opportunity. And then, of course, my biggest concern, which I think is something that all of us in-house are dealing with, is just getting the necessary attention for these changes given the pandemic. We're all making big decisions about whether or not to return to campus. We've got a lot of things happening with the immigration space, which we've been dealing with this week. People are really, really focused on a number of really important issues, including Title IX. So finding ways to get that attention is important. I'm going to move forward to the next slide, just to very quickly talk about low-hanging fruit, things that you can be doing or delegating to folks while you're working on some of the bigger issues. I think most of us have a non-discrimination statement, and it probably just needs to be updated a little bit. Take a look at it one more time. Updating publications, making sure that your catalogs, employee handbooks, et cetera, have what you need, not just in terms of the definitions and your policies and procedures, but other policies that might dovetail with those policies and procedures. I also think most of us have supportive measures already, which we probably call interim measures or something else in our policies and procedures, taking a look at those, making sure that they're comprehensive or determining whether we want to add more. This is actually a really great place to collaborate with employees who might have a better sense for what types of things they might find helpful through like either a study group or a group where you might convene some folks to give you some feedback. We've done that at Tufts through our sexual misconduct steering committee, and it's been really helpful. Evaluating and realigning necessary reporting and responsibility structures. There's a lot more responsibility specifically and very clearly delegated to the Title IX coordinator, particularly with respect to making sure that the supportive measures are being effectively implemented. If those measures are not being implemented by the Title IX coordinator, making sure that there's that connect, I think, is going to be really important as well. And finally, I talked about this already to some extent, is just the training of key players on regulations and changes. I think, you know, for all of us, making sure that folks in leadership are aware of what the regulations are, how they might, you know, come to their level, because you may very well have employees or faculty who will go either to the provost or the VP of HR saying, well, what do you mean I have to show up for a hearing? Or what do you mean, you know, everyone's going to know that I filed this complaint? Some of the education is going to have to be to leadership so that they can handle those difficult conversations, or at the very least know who they can direct those difficult conversations to. Okay, and with that, and hopefully, you know, some of this is all coming together. We have a little bit more than a month, I guess, to get this all together. And in the meantime, one of the things I have found really helpful is working through hypos. And Scott has put together some wonderful hypotheticals, which maybe we can begin to work through.
Sure. Thank you all both. That was great. I noticed that one of our participants is the deceased Albert Camus, which that was interesting addition. But it's also fitting because I think the upcoming semester for higher education is an existential one. So there you see, I worked it all in together. Wasn't that impressive? I think the upcoming semester, and you all alluded to this, is probably the most complicated as far as I'm aware of in the last century. You know, first we are trying to figure out the pandemic response and what our responsibilities are in that space without a lot in the way of national guidance. We also, and this has taken up a lot of my time recently, been responding to the race-related issues that have been occurring on campus. We have an election coming up in November. And then for me, you know, down the list, and it's remarkable because as Seth, you know, astutely pointed out, I mean, this is the first time we've had regulations in this space since 1975 are complying with the Title IX regulations. I mean, it is going to be a really, really, I can't think of a parallel in terms of the challenges that are facing higher educational institutions in this upcoming semester. And what I've been doing as far as the Title IX regs is working through, well, how does this relate to, and how does this maybe conflict with our obligations under Title VII? And in the long preamble to the Title IX regulations, there is glib, at least in my opinion, glib treatment of this issue, where the department basically says in fairly conclusory fashion, there is no conflict between these regs and an institution's obligations under Title VII or other laws. And I don't think that that is a fair characterization. And so I came up with some of these hypotheticals to sort of work through some of the areas of potential conflict. And so rather than me babble on, and I'm looking forward, hopefully folks make some comments in the chat box, to working through these hypotheticals, including you, Albert Camus. Come on, get in. What if? Yeah, well done. Was that Seth?
It was. I'm still puzzling though, Scott, about how you don't read the language that nothing in the final regulation shall be read as a derogation of an employee's rights under Title VII. How is that not clear?
Yeah, there you go. It's very clear. Seth with a Camus reference and an Iran-Contra reference in less than 30 minutes. It's very impressive, sir. So what if, and here's hypothetical number one, what if Professor A, which is an unfortunate name, is accused of sex assault by a minor student? The student says that Professor B witnessed the assault. The investigator in our Title IX process, because this presumably triggers our Title IX process, asked Professor B to sit for an interview, and Professor B refuses. And so the question is, well, first off, let's issue spot a little bit here, but what are the options that we have in dealing with Professor B's refusal in this regard? And I'll back up and give some context to this. My background, I think like everybody else's, is in employment law. I occasionally just miss the Fortune 500 clients. There's less drama. I love higher ed, but I miss the safety of the business world. But if I were to go to an employee who was a witness to harassment or discrimination or the sex assault of a minor in normal HR world and said, hey, you have this information, you need to sit and be interviewed for this and participate in our investigation. And if that person said no, what would typically happen? I think you would say it's either yes or you're no longer here. And so the question is, the hypothetical poses the question, well, what options do we have under the new Title IX regulations in that hypothetical? And so I'm going to throw it out to the group here. What do you think?
Well, I'll start. I have to say that before I even answer your question, this is the type of scenario that I hope none of us ever gets, but it just largely is a type of situation that we should be thinking about as something that would be really stressful for our Title IX folks and for the folks on campus who might be thinking about having a minor student's claim going through a hearings process. So managing this type of a scenario, I think, from the beginning is an important one and probably a very good one to manage in training. As far as the Professor B sitting for interview, I thought this question was interesting because Professor B, when I think about the definition that was added or the description that was added to retaliation in the new regs, I don't think Professor B has any rights under Title IX that would prohibit us from doing what you're describing you might do in the Fortune 500 space here. And at the very least, what I would expect someone to do in this case is to at least talk to Professor B about how important their participation is and ask Professor B to, sort of understand that this is a really serious allegation and that, if they saw something, we would really like them to participate if, they're able and willing. I don't know if Seth, you or Scott have other comments, but.
Yeah, I agree. I think we'd issue a directive and expect that at least Professor B would have to sit there and honestly address questions, whether, to the extent that they would provide full, helpful information, come forward in a way that would allow us to proceed would be questionable. It's a professor, so they may assert some kind of right to academic freedom or something like that. I don't know. But we would definitely want to pull out all the stops in order to make them make their obligations known, and their obligations as part of the institution. Our obligations run through them to some extent in a case like this, and our obligations are certainly that important that we get to the bottom of this, that we pursue it. I would also suggest, and this may be a road too far, but for some people, but since it involves a minor, I would at least, if Professor B I thought they had particularly valuable information, and they were really stonewalling us, I may raise the specter of loss of indemnification during future proceedings through Professor B if we really needed to put some pressure on.
Yeah, so there's an interesting, and it's in the chat, one of the interesting things, and I'm curious what you all think of this, in the Title IX regs, there's this really broad definition of retaliation, and just happened to be able to pull it up quickly. No recipient or other person may intimidate, threaten, coerce, or discriminate against any individual, blah, 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 for refusing to participate in any manner in an investigation, proceeding, or hearing under this part. And really part of what the hypothetical was designed to do was sort of, by disciplining, let's say we cannot cajole Professor B to participate in our investigation, and we go, aha, we're moving forward with discipline. Would that potentially run afoul of this very broad retaliation provision, because Professor B is refusing to participate in the investigation? I see in the comments some questions about, is he a mandatory reporter? Well, that's going to be a state law question, and I think in virtually every state he would be a mandatory reporter, but that's separate and distinct. Making a report is one thing. Participating in the active investigation of it is something else. If I have follow-up questions, all that sort of stuff. And so this hypothetical, I think, was trying to highlight a little bit sort of the broad nature of that anti-retaliation provision in the Title IX regs. I don't know if anybody else had any thoughts about that one.
Yeah, I mean, I'll be candid. I find this particular provision to be not only difficult to understand, but so broad that I can't imagine that it was intended to be so broad. I know that some folks have actually used the Open Center for OCR that OCR has set up to provide answers and clarifications on the regs. This may be one of those that might be warranted. But again, my experience has been that really sitting down with the person and having the individual fully understand why their participation is so important has usually saved the day. So, I would hope that you wouldn't have to even get to a place where you would have to discipline someone or otherwise, act. But again, I'm not sure if this particular provision really intended to completely shield an individual who refused to participate in any manner, when in fact the individual might potentially have, if there's a policy or procedure that applies just to employees, that would require or support their cooperation in investigations.
Yeah, and can I chip in? Yeah, and I want to chip in and give some big picture perspective as well. And this might be a little controversial, but so be it. There are always times, and we do this all the time, I think, in the context of, I know Jeff was going to be our moderator. I stole Jeff's FERPA Schmerpa motto a long time ago, but much to my chagrin sometimes. But we need some perspective. a violation of these regulations means that we will be potentially within the enforcement scheme of OCR saying that we violated the regs. To the extent there is ever any tension between Title IX and potentially being within the, subject to a compliance review of some sort under the Department of Education or broader institutional liability issues, we might have to decide, we might have to pick. And I do think, despite what the department says, they are going to put us in situations like that where we have to make those decisions. We're going to have to pick which piece of litigation or which piece of compliance we're especially concerned with. And so, like in my opinion, Professor B has really important information here and is refusing to participate. And what we're left with is a determination institutionally that Professor A is going to stay on board despite the fact Professor B had really compelling information or refuses to participate in a hearing. I might say to a client, hey, let's run the risk of running afoul of an anti-retaliation provision, make the argument that it can't apply in this circumstance, because the alternative option is a lot more distasteful to me and should be more distasteful to the institution.
And one thing that I'm watching a little bit of the chats, which are really good questions and comments. For anyone who's handled one of these very difficult cases, these cases get pulled out of the institution pretty quickly by the police. And Professor B may not want to answer to the institution, but the professor will likely have to answer to a subpoena or some other legal process that's going to proceed. And you're right that there, at least in Massachusetts, there could potentially be, under an institution's policy in particular, an obligation to report this matter. Likely there will be. So there's a lot of moving parts here that may make this question academic, but a good one to consider nonetheless.
With respect to the question about wrongful discharge, Eric proposes that this professor could later say, I'm protected under Title IX and you fired me nonetheless. I guess I would try to split a hair a little bit here and say that when Title IX prohibits our institutions from retaliating against someone, even in this context where it seems kind of absurd, that's different from giving that individual a right, I would say, a legal right to be silent. I think that, and as Lili mentioned, this may play out in a very different forum if you talk about potential criminal liability for sex abuse of a minor child.
I want to go back and reread the Jackson case, but that I mentioned earlier. But when that extended Title IX to retaliation, it was doing it in a very different context, and I'd be interested to see how courts would interpret this kind of extension if Professor B tried to extend or tried to grab onto some individual right that they had under these regulations. I guess my best defense would be I pursue it, as Scott said, because it's a pick your poison question, and the poison that I would pick is what I would describe as a technical violation of a Title IX regulation that hasn't been yet clearly defined. The contours of it have not been clearly defined by courts or anybody else yet, and say I don't even know if we've initiated a process. I understand that the language says or investigation, but at this very early stage where we're just sort of gathering information and deciding what there is to even investigate, I'd take a position, I guess, in order to make the best possible argument that that we're not there yet. We're not within the context of proceeding under these regulations yet, as we're sort of looking for access, looking for information.
Yeah, the one thing I'd chip into, I see Eric's question. I would not assume that the regs, failure to comply with the regs automatically implies a cause of action, a private cause of action. I think that'll be a hotly litigated issue, but I certainly wouldn't assume that at this point. I want to be sensitive to time, so I'm going to go to the next hypothetical. I think we have three. Is that what I did? It was a long night last night. All right, number two. What if employee A goes to HR to express concerns that the provost is making sexual comments to employee B on a regular basis? HR reaches out to employee B, who confirms the sexual comments but says, I don't want you to do anything about it. I'm not filing a formal complaint against the provost. How should you respond in satisfying your obligations both under Title VII and Title IX?
Seth, do you want to start? Or?
I can give my take, which would be that you're probably going to end up without a formal complaint, a quote-unquote formal complaint under Title IX. That process is going to be somehow discontinued, documented, and you're going to move on to a Title VII type investigation or state law investigation very, very quickly. That would enable you to pursue this with, I guess, a little bit more vigor.
So
it's a pretty short answer, but I just don't. If you don't have that formal complaint, you don't really get too far down the Title IX process, which in this case I would probably view as a good thing because it frees us up to pursue it with a little bit freer process, a little bit more traditional process. What we're a little bit something that's a little bit more familiar to us.
Seth, and what would you guys do if, like, your Title IX coordinator wished to file a complaint on behalf of the complainant here because of the sort of the seriousness of the allegations against the provost, who's the chief academic officer? What do you guys think about that, Seth or Scott?
Yeah, I think that's what you're left with here is that the complaint is serious. And look, the backdrop here is, in Title VII world, if an employee is being harassed and says, I don't want to do anything with this, we're not at liberty. And there's case law, certainly in the Fifth Circuit where I am in Austin, Texas, that says, no, you're on notice, you need to investigate and do something. So it was trying to pull out that tension. But from a Title IX perspective, I think what you're left with is, all right, we're going to initiate that process by getting that signed Title IX coordinator complaint. My concern with that, I'll just be blunt, is that seems like, all right, cool, we've got the process started now. What's going to be the end result of that process in the absence of a participating employee B? Now, maybe we can get a finding of responsibility based on testimony from employee A or other participants and witnesses, but in the absence of a participating complainant in our process, are we going through the motions with an understanding that we know how this is all going to resolve itself? Does that make sense?
I think it does.
Yeah, I think another consideration here based on the language of this is the severity of the comments, because we may be able to sort of slip out of the Title IX context and slip it into Title VII by saying we don't think that, or we don't have enough information at least to process this as a sexual harassment complaint under Title IX, but we're more comfortable doing so under the definition of Title VII. I guess I'm trying to find a way to get us out of the Title IX process so we can pursue it under Title VII with a little bit, as I said, a little bit more vigor, a little bit more freedom.
Sure. Yeah, there's no question that, particularly given the allegations against someone like the provost, who would be an alter ego under Title VII and the EEOC's view of what's going on here, you'd really want to be in a position to, regardless, investigate this and take, appropriate action, regardless. So I think that once you pave that way, you're golden. So.
Yeah, I mean, the only, so when there's some comments, and I think Kim S. is hitting part of it. You know, when I said very early on, the department says that the obligations are completely reconcilable. I think in reality, if you process this through our 9 process, we're going to end up with a finding, let's just say arguably because we don't have a participating complainant, with a finding of non-responsibility. Whereas if we go through a Title VII process, so we exhaust Title IX and we say, but we're not done. And oh, by the way, if you're going to do that, you need to draft a policy that allows you to do it. And arguably, I think the department's not very clear on this. Does having such an approach run afoul of another portion of the anti-retaliation provision? But if we go through our 7 process and the person sits for an interview, we come to a completely different conclusion that yes, the provost violated our anti-harassment policy or Title VII policy. So to me, it's an example of, yeah, there is some tension between our obligations under 9 and 7, or at least the end result of the process is completely different in the 9 setting than it was in the 7 setting.
So I guess just zeroing in on how soon we can get to that conclusion of the Title IX process, one of the things that I'm looking at is the dismissal of a formal complaint language, which says that the recipient may dismiss the formal complaint if circumstances prevent the recipient from gathering information sufficient to reach a determination. I'm thinking, you know, we don't have a lot of information here, but I'm thinking if we don't have a willing complainant or willing, I guess, witness in employee B here, that we're going to reach that pretty quickly. We're going to reach that conclusion and be in a may dismiss stance, and we may dismiss it. Again, that's only dismissal under Title IX, and then we move on to Title VII promptly. And I'm just shorthanding the Title VII complaint, another violation type of investigatory process that gets us out of the regs that we're all here to talk about.
I guess I'll just, I don't want to confuse things further, but I guess I'll just say that I know a lot of Title IX coordinators may be interested in kind of moving something like this forward simply because it may provide the complainant with the comfort to come forward if they are not the actual complainant initially. And I think from your hypo, employee A, I'm assuming employee A has, you know, firsthand information about what's going on, but maybe that's not true. You know, so again, you know, in terms of process being afforded, these are the types of things that I think I would be talking about with my colleagues about, you know, what are the real, there's a lot of facts that we would, and I'm assuming, but, you know, really scouring what's going on here and why the person doesn't want to do anything about it may actually inform the process that you follow. And also just the...
Yeah, and there's a weird provision, again, it's one of the benefits of being able to do this remotely, and there are very few, by the way. I so much prefer being in Burlington, number one, and being with other human beings. But one of the advantages is I can pull up the regs really quickly. And so there's this language here, and it's a head scratcher for me as to what it's designed to reach. Intimidation, threats, coercion, or discrimination, including charges against an individual for code of conduct violations that do not involve sex discrimination or sex harassment, but arise out of the same facts or circumstances as a report or complaint of sex discrimination, or a report or formal complaint for the purpose of interfering with any right or privilege secured by Title IX constitutes retaliation. Is that provision designed to preclude us from going through to, you know, moving to the Title VII process, or is it supposed to be covering something else? I don't know what the answer is, and it's just not very clear to me.
When it says code of conduct, talks about code of conduct, and doesn't specifically mention Title VII, and Title VII is mentioned elsewhere, in the guidance, in the preamble, saying that nothing in here is supposed to conflict with Title VII, that's not our intent, then I would interpret that as saying you're not supposed to bring, you're not supposed to issue the person extra parking tickets or something like that. Not that you're not supposed to pursue your Title VII investigation separately after you've determined that you've sort of safely removed it from the Title IX process.
Yeah, I think that's where I am as well. Yeah.
Scott, want to move to the next third final hypothetical?
253, okay. What if employee A claims supervisor is subjecting A to pervasive and severe racial and sexual harassment? During interviews, employees B and C corroborate the claims with extensive, consistent detail. At the hearing, employees A, B, and C refuse to appear, fearful of the retaliatory supervisor. Because no one attends the hearing, supervisor is found not responsible for the sex harassment. The investigative report of the sex harassment and interviews clearly support the finding of severe or pervasive, unwelcome sexual conduct. And so there are a couple of things going on here. First off, intersectional claims, that we have a sex discrimination claim, which clearly triggers our obligations under Title IX, and a race harassment claim, which triggers our obligation under Title VII. And so my first question to you all is, logistically, just on those facts alone, how do you move forward? Is it twin tracks? Do we do the VII one, the race claim first? What are your thoughts on that?
You know, I love this hypothetical because I think this is really the most difficult scenario that we've been noodling, and we probably won't, every circumstance is going to probably lead to a different scenario. But as you're thinking about your policies and procedures and revising them, I think being very clear about how you will handle something like this is going to be important, while at the same time giving yourself some flexibility. My guess is that, I don't know, my view is that the most efficient way to handle this, if you think that Title IX is triggered, is to have one process, not two separate processes, have an outcome, but make clear to some extent that this sort of finding of not responsible is it not responsible for a particular part of your policy or specific to the Title IX policy, let's say. I just think that having two separate tracks is confusing. I'm not sure if other schools have done that, but we're at least looking at one single one. So I don't know what you guys think about that.
This one really.
Yeah, I'll add a couple.
Sorry, I was just going to say that the inclination, I think, is to go single track because that's economical. But this one presents us with the downside of that, which is that you could find yourself in a situation where you're unable to address conduct that you really want to address because the process that you've used is too narrow to allow you to address it. Whereas if you use parallel tracks here, then you could, I think we could see how you could dismiss it under Title IX sex harassment and then continue to pursue it as a Title VII racial harassment claim.
Let me say one thing about this hypothetical, because it illustrates, at least to me, what is the most problematic part of the 9 regulations, and the part that I think creates, at least, again, for me, a lot of concern is the most significant part of the Title IX regs is an evidentiary rule. That if we are on notice of allegations, we've talked to employees B and C and A in an interview. They have provided the institution with information. But because they refuse to go to a hearing, we must, under the Title IX regs, pretend as if we never heard any of that. And I think that's, I have a variety of opinions about the regs on the whole. I think there's some good. I think there's some meh. this is one of the most alarming parts of the regs to me, is that it would put us in the position of employing a process that, under this hypothetical, requires us to ignore evidence that we have gathered in the course of a review. As far as how we process this one, I think, to me, and again, when you sit, and I was working on one all night last night, and it makes my head hurt, and somebody can free ride off of this at some point. How do we draft a policy that contemplates this situation, which I don't think is all that unusual, and then says, and this is how we will proceed in that sort of situation? And the way I think about it is, we will have our 9 process here run by these people, and then we'll go through our 7 process on the race claim. And if at some point the race claim, we can get it done fairly quickly, which I think part of the 9 process is, boy, this takes the investigation, the hearing takes a long time, almost by design. If we conclude that there is evidence of race harassment or discrimination that warrants a termination of someone's employment, we can do that pursuant to our Title VII process. And there's an avenue in the 9 regs that says, look, if the respondent is no longer employed, we can stop our 9 process. And so structurally, I think I would have 2 twin things going on at the same time, and see how it plays itself out.
At will, I agree, that would be the way to go. Ideally, by the time you got through the second sentence here, the person is gone, right? You've got enough evidence to determine that they've committed racial harassment, and you terminate them. And then now the person's gone, you can terminate the Title IX complaint because they're no longer an employee. But for many of us in a collective bargaining environment, we may be able to refer that to a grievance process under collective bargaining and start taking action, but we're still going to be stuck with that Title IX complaint that we've got to process, and so maybe that'll lead to a second referral later on. Maybe not if they refuse to appear. I guess but again, it sort of illustrates the benefit of going to separate tracks, going parallel tracks, and pushes back against, I think, what is my natural inclination, which is to go the more economical route and try to do everything in a single hearing when you have mixed claims like this.
Yeah, and I think, we're all working through all of these details and everyone's policy and process, and, if you have a unionized facility or not, all of that is going to play into it. Because certainly with unionized employees, some of the concerns that folks have are that, in addition to going through a hearing process, you're going to then have to go through an arbitration process potentially if the matter gets elevated through the union. So anyway, lots to talk about.
So in a unionized setting, it's even more complicated, but in an at-will setting, it's still super complicated as well.
Sure.
I didn't want to go over. Yeah.
Well, we started a little late, so we could go a few minutes longer. Hopefully that's okay with our audience. But just want to call your attention to Jen's question, in which she proposes using the Title IX process, but empowering the Title IX hearing officer to make conclusions or findings that would then be somehow usable for a Title VII adjudication. Not sure that the current regs prohibit that kind of approach. It would be threading a needle, to be sure, like everything else is about these regs.
I would want to have a really smart hearing officer like Tom that I could eventually use as a witness that could explain how he separated out, how he unthreaded that needle, and was able to sort of segregate that information, the evidence, into 2 separate piles and make 2 separate decisions on it, which is, that's a heavy lift to make that to an investigator or to a court, try to explain how you've done that, especially if you're doing it 2 years after the hearing was over.
Other thoughts, other questions? I keep coming back to what you all had mentioned earlier, the idea that at least right now, we don't know for sure that Title IX grants individuals in these processes a right of action, a right to sue, or a positive right to come back and claim that they had a right that was violated. That's an important open question, and it seems like the department would be really treading on very thin ice in terms of credibility and logic to take that position in these hypotheticals, but we just don't know that yet. And these cases seem to present the classic choose your lawsuit scenario, or in this case, choose a lawsuit versus an OCR investigation. When you've got serious harassment or serious sexual assault or sexual assault of a minor, it's hard, reminded of Jeff Nolan saying FERPA schmerpa. I mean, let's say Title IX, Schmeitel 9. I mean, these things are pretty serious. And the fact that we're noodling over these rules, aside from pointing out how difficult and poorly written they are, also points out, as our friend Albert Camus pointed out, how absurd this can be. May I turn to each of you for any closing comments? Lili, I'll go to you first before we wrap up.
I want to thank the University of Vermont for this opportunity, because I have heard a number of conversations where I've heard folks say, oh, this is just applying to students. And I think some people have been sort of led to believe that Title IX doesn't apply to employees. And I think it was an important session to have. So hopefully nobody's in that camp. But talking about these very difficult issues, which I think Scott captured perfectly in some of these hypos, is going to be great for anybody on campus. So thank you.
Thanks, Lili.
I'll chip in and let Seth clean up. I don't know what I said, but yeah, I think for our student conduct folks, they've been dealing with a very bureaucratic system for a better part of 5 years to almost a decade at this point, and are used to it. Our HR compatriots, especially in spaces that aren't unionized, have always been much more informal in terms of documentation and report writing. What Lili says is exactly right. I mean, no, these regs and all of the concomitant bureaucratic requirements now apply to certain employment situations. And we need to make sure that the folks in HR who have been, maybe not as robust as our colleagues in student conduct and student affairs catch up. And so happy to have the conversation, happy to answer any questions offline you might have, and good luck to everybody.
Seth?
Thanks, everyone. I'll just close by saying take comfort that we still have a full 5 weeks to figure all this stuff out and get our policy straight and our training done and ready to apply this. So
that's encouraging. Thanks. And on behalf of the Board of Advisors of the University of Vermont's Continuing and Distance Education and Legal Issues in Higher Education Conference, thank you for attending today's webinar. Our next session, the fourth in our series, is July 23rd, so save that date. Its topic is new regs, new procedures, managing live hearings, cross-examination, and more. And we hope also that you will consider joining us online for this fall's 30th Annual Legal Issues in Higher Education Conference from October 29 to October 21st. Thank you to my crew here at UVM, everyone who makes this series possible. Thank you again to the audience for joining in. And again, a recording of this session will be made available and sent out to all of you after we conclude today. Thank you.